Hello everybody, and welcome to this version of Chapter 9. This is a really short module, Alternatives to Traditional Prosecution. There's basically 2 points that exist in here. One is, can we better serve the public? And if we look at the first dilemma, individual rights versus the common good, can we better serve the public and the individual through various alternative methods of prosecution rather than the traditional ones? And then how might intercept models interface with this? So we're going to look at those two. Just a long list and definitions, not a long list, a relatively short list of alternatives to traditional prosecution, and then the intercept model that can funnel people into various aspects of non-traditional dealings with their interactions with law enforcement and the court system. So here we go, and welcome to the cattic. This is the cattic, so this is our master bedroom, bathroom up here. I built this, I don't know, about 10-12 years ago. It was a bare attic, and now it's actually a master bedroom and bath suite. But for now, guys, we got to adapt, right? It's a freaking studio. So let's see how this works out and move on from here. So let's get started. Like I said, it's a brief lecture. It's 2 parts, only about 14 slides. We're going to talk about the alternatives to traditional prosecution and the intercept model of intervention. Alternative dispute resolution, various formats, arbitration, summary jury trial, mediation, and beliefs about alternative resolution. These can be applied to both civil and criminal cases, and I know we haven't talked a lot about civil cases yet. And civil cases is one party sues another, right? So it's kind of deviating from the idea of criminal cases. But these alternative dispute relation techniques or models can be applied to both. It reduces the number of cases going to federal court, and that's what's expensive, is when we're sending things to federal court, we involve a great number of people, we increase the demand on the court docket, and a lot of times there's less expensive ways to get through this. So, for example, the number of cases going to federal courts, what does it say here? Civil 11.5% reduction, 1962, to 1.9% in 2009. That's a huge reduction, right? That's almost like a 9-fold reduction in those cases. The criminal cases from 15.4% to 4.7%. Why do we do it? Well, it's a greater pressure from the courts to settle and not have to go through lengthy court processes, and through this we see cost savings that are attorney fees, expert witness fees, etc. So there's a big push to do this. Now, what are the different types? There's negotiations. So we can negotiate labor contracts, personal injury settlements, and or divorce, and that might be a collaborative divorce situation where we look to settle a divorce without going through the full-blown court routine. Now, arbitration is another technique. This is closest to the trial, and arbitration can create a binding agreement. In this case, evidence is presented, and an arbitrator makes the ultimate decision. Now, summary jury trial, probably the least used out of this. Evidence is presented by attorneys, instructions from judge, jury advises, saves time. Rather than have a full trial, this is almost kind of somewhere between, let's say, a mock trial and a genuine trial. But the idea, again, is to save costs in doing this. Other forms, mediation. Mediator's a facilitator, unlike a decider. When you have an arbitrator, both parties agree to be bound by the arbitrator's decision. In mediation, the mediator is a facilitator trying to facilitate agreement between both parties. It's often called shuttle diplomacy because you'll see a mediator perhaps shuttle back and forth between parties to make this discussion. Interestingly, my wife is a paralegal, and she often volunteers to be a mediator for Franklin County courts. She and an attorney will work together and try to mediate disputes and have the parties then come to a mutually agreeable decision. Note how this is done. This would be done in the evening. It's done after work. Both parties assemble at a room in the courthouse. But there's no jury, there's no judge, there's no huge process that takes place in this. Common to all, what's up about this? Well, general perception of fairness. And that's as long as people believe they've been understood and they've been heard. People generally tend to think that this is a fair process. Generally favorable reactions tied to personal control or belief in personal control. And then risk aversion feeds into this, the parties deciding their fate rather than leaving it in the hands of an unknown third party, and often people prefer to state their own case, let the chips fall where they may, but they feel they've had control over the situation. So that pretty much summarizes alternative dispute resolution. Now it's to the second part of our module, and I warned you this is a short one. Let's talk about the sequential intercept model. Now what we're talking about is how do we typically deal with offenders as opposed to how might we deal with offenders in the future in a more precise fashion, precise in terms of does the treatment match the level of the offense, so to speak. So in the sequential intercept model, we're going to describe the 5 stages, right, of criminal justice system, which the traditional system might be interrupted and a new course taken along these steps. Generally, it's to substitute some kind of community or alternative treatment. So, for example, law enforcement, emergency services, so paramedics, law enforcement, usually represent the first point of contact with an offender or an injured party. So, in this case, police are then working to develop, in some departments, crisis intervention teams. And these are teams that have special training, specialized in dealing with certain types of incidents. Right? So the specialized police responding crisis intervention teams, if it's a mental health team and they're called out because we have a potentially mentally ill suspect, they have the training to deal with a mentally ill suspect, and they're more likely to then recommend some kind of mental health treatment, some kind of mental health intervention, rather than, let's say, a jail intervention for the party. So they're less likely to use force and escalate the situation because they understand the nature of the offender to a greater extent. What we find then is this often generates less harm to the first responders. So once first responders understand how the system works, their buy-in is usually pretty solid because we sell it in 2 points. It's better for the offender, but it's better for the first responders as well. And the cost reductions can be significant in terms of lawsuits, in terms of not going to jail, and using the traditional models. So, again, remember 5 steps where the intervention can be placed in a non-traditional fashion. Law enforcement, emergency services, the first step. Now, for the second step, this is post-arrest, initial detention, hearing, pretrial services, as we've discussed. We appear before the judge. The judge then can identify people that might benefit from treatment rather than the typical jurisprudence process, putting them in jail, having trials, etc. They're most likely to send people to treatment or assign specialized probation. What we see now is we've seen this burgeoning of drug courts. So when we have a drug offender and the harm is basically to themselves, can we get them some kind of rehabilitation? We see veterans courts that are new, that looking at the problems of veterans often as being different than the problems of the general public when they're engaging with law enforcement. So perhaps going to a veterans court and not a full-blown court finds them the resources they need and solves the problem without the necessitating detention. We might see homeless courts where they specifically deal with homeless people. We might see family courts, etc., juvenile courts. So it in part spawns this breadth of courts that are more specialized and deal with people in a way that's more conducive to their problems. Initial research shows some positive outcome. Correlational research, of course, has its shortcomings. There is no random assignment in that case, but quasi-experiments can often be used to address this shortcoming. And a quasi-experiment is when we can't do random assignment, we still compare 2 groups on a critical aspect, but we acknowledge that random assignment was not possible. In real life situations, quasi-experiments are often a much better way to go. perceived positive social outcomes in more time in the community, fewer arrests, less homelessness as a result of these processes. Post-initial hearing, this is the third step, Intercept number 3. Jails, prisons, courts, forensic evaluations, commitments, most recognized. So these problem-solving courts, as I was describing, chronic adjustment problems, reduced recidivism, combines traditional jurisprudent techniques with specialized treatment programs. Interestingly, there's a judge up in Richland, Ohio, who was one of the pioneers of these types of courts. Drug courts, veteran courts, to take people out of the traditional prosecutory simple. And for example, then you might call this therapeutic jurisprudence, immediate interventions and treatments, greater monitoring by courts, less adversarial in nature, right? And think about how that might dovetail with finding the truth versus resolving conflict. These courts are often very much in terms of resolving conflict. Greater and compliance often rewarded by sentence reduction or dismissal. So if you complete this program, then we'll in fact revisit your sentence and probably then just let you go as time served. So drug courts, mental health courts, homeless courts, domestic violence courts, community courts, veteran courts. So you can see Intercept 2 and 3 either either at the initial hearings or post-initial hearings, people can be channeled to these various alternative courts. Now the fourth intercept is what do we do when we let people out of jail? And I don't know if any of you watched The Shawshank Redemption, but I think it was always a good example. You see people who've been in prison for just all kinds of time, for 20 years, 30 years, etc. What happens? Well, they come out and I remember in the movie they're sent to work at this grocery store. They have no idea what it's what it's like to be out of prison. They don't know how to function. They go back to a room that's been provided to them. So they've had their job, their room provided, but no additional support beyond that. And we know in the movie, we saw the tragic case of the guy not knowing what to do and hung himself in that room. We need to integrate people to a greater extent. That's the belief in these systems. We need to integrate people into these new interventions. For example, as I'm standing here, I can look out the attic windows and there's a house across the street. This house has been vacant on and off for the 20 years I've lived here. Finally, it's been purchased by a gentleman who is a former drug addict. And he got clean, he's got a job, he buys these houses, and it now operates as a halfway house. So we see people who've been diverted from the drug court system who now go live in this house. They're supposed to work and they're supposed to be reintegrated into society. And then Intercept 5, while on parole following release from incarceration, is another way to look at this. Most parole officers are tremendously overworked and overburdened. So these courts try to step in, these interventions, halfway houses, post-release counseling to help people not recommit, or go back to drugs or what have you. Will the trend continue? Hard to say. Often these are political ideas. Some people tend to be harsh in their philosophy. Hey, you break the law, you need to get punished. This is kind of a different approach. Often people describe this as a more liberal approach. You broke the law, society has failed you, and we need to find ways to bring you back into the fold to make you a member of society. So, what we need to do, though, is we can return back to needs assessment, program design, and program evaluation. And let's look at a couple of these quick reflection questions. That is, to what extent can we determine these programs are effective? What determines effectiveness? And we know we should build that in at the design phase. That is, so that when we come to the third phase of program evaluation, what measures are going to let us determine whether this program can be deemed effective or not. And that's something we need to build into the design and then measure at the evaluation stage. Right? What negative consequences may occur as a result of these newfangled ideas? And this is where I'm big on listing pros and cons. What could possibly go wrong? I had a boss who used to say that. Pete always said, what could possibly go wrong? And that would always make me shudder. But the idea is, what could possibly go wrong? Hey, we better anticipate that. And for anyone who doubts that, as we sit here in the middle of this pandemic, 3 months ago, a lot of people 2 years ago with the pandemic, 3, 4 years ago with the pandemic response team is, what could possibly go wrong? What if a pandemic hits our shores? What are we going to do? How are we going to prepare? It's important to plan for potential horrible contingencies like the pandemic we're in now. And then, does the adoption of these programs demonstrate a shift away from the crime control model, right? And are we moving to the due process model? And you can make kind of your own judgment on that. So, as I said, it's been a short one, 2 basic, huge take-home points, right? The second take-home point is, look, we can intervene at these various places, and the first point was that alternatives do exist, and it really is up to us to imagine and to explore these alternatives. So you guys take care. That's the end of that one, and we'll see you in Module 10.